A member for Maitland.
Thank you, Mr Temporary Speaker. I rise to speak on the Justice Legislation Amendment Bill of 2018, and in particular I seek to address the issues raised in Schedule 1.4 to amend Section 73 of the Crimes Act. And I'd like to take this opportunity to thank the Attorney-General and his staff for the briefing that I received, particularly on this issue. This legislation is being changed basically to close a loophole in the case referred to by the member for Mile Lakes of a teacher who was not the current teacher of a student and who was able to successfully challenge the charges. Now, in this section, it is in Section 73, it's to omit Section 73(3)(b) and insert instead that the offender is a member of the teaching staff of the school at which the victim is a student, or and to go forward from there to say that in this section, member of the teaching staff of a school means a teacher at the school, or the principal or a deputy principal at the school, or any other person employed at the school who has students at the school under his care or authority. Now, I was very interested to hear the Attorney-General's second reading speech on this matter, particularly where he was very clear on where this amendment would not apply. So he said, and I quote, that the amendment will not expand the scope of the offence to school workers who do not have students under their authority or care. Examples may include a groundskeeper or office staff who perform purely administrative duties, such as an executive assistant to a principal. This recognises that a power imbalance is less likely between these workers and students. The court would be in a position to consider all of the circumstances on a case-by-case basis, and this amendment has been urgently processed to close the loophole. It would be referred to the Legislative Council Standing Committee on Law and Justice, etc. This is worthy of discussion. Is it really less likely that a power imbalance will occur between a student and any adult who is employed in a permanent capacity at a school? I think we need to look at legislation which reflects a change in attitude in our society, and that is that using power to have sex with someone is wrong. It's either wrong or it's not, and I think that what we've got here is an opportunity to change this legislation, but I would say that many people out there in the community would say that this does not go far enough. As the mother of a 16-year-old daughter at school, I would have to say that I would not be happy to hear that a groundskeeper or a member of the administrative staff of that school had initiated a sexual relationship with her, or if it had been my son at the same age, same thing. No one cares if people have sex with each other outside of schools or who they are, what they do. That's a private matter. And this is not, as some would say, about raising the consent from the age of 16 to 18. All I'm saying is that there are some institutions in our society, and I would count schools as one of these, where it should be clear to everyone that staff and students cannot engage in a sexual relationship without there being an element of a power imbalance in there. The question from those who don't think this loophole should be fully closed to include groundskeepers, admin staff, other workers in schools, is that should the maintenance worker or the admin worker be charged as a criminal for having a sexual relationship with a student? We know that in public schools this would be covered under the Code of Conduct, and that in a lot of private schools that Code of Conduct would similarly apply. But if we only allow such an offender to get sacked and not charged with a criminal offence, does that guarantee that they won't be able to go to another school system and or another state and do the same thing? How can we guarantee that all schools have this protection? Section 5A of the Teaching Service Act holds that the protection of children is to be the paramount consideration in taking any action with respect to an officer or temporary employee. By omitting school workers who are still in a position of power, this bill is not making the protection of children its paramount concern. Now, some of you may say, what role, what power, what authority does a groundskeeper in a school have? He or she may be friends with the person who marks that student's assessments. They may be friends with that student's year assessor. student advisor, anything like that. The attorney acknowledges that when a staff member has the power to issue directions to a student, there's a power imbalance present. Now, groundskeepers, office staff and administrative staff can all issue directions to students. In fact, I think if members asked any of their children who have been at school or even thought back themselves, sometimes the administrative officers of schools are the scariest people out there because they're the ones that determine whether you get to go on the excursion, whether you get to enrol in the course, all those sorts of things. I just can't see why we are protecting the right of people to have sex with our kids at school over the terrible injustice and terrible lifelong complications for students who are impacted by people who take advantage of them because of power imbalances. If one of these staff members makes a sexual advance towards a student, it is clearly a contravention of what the general public considers acceptable. Ask yourself, when you were 16 or 17, if one of your teachers had have made an advance to you, and don't imagine that it's a walk up, let's go for it. This would be after months and even perhaps years of grooming. How would you feel? How would you tell that person that you are not up for that kind of relationship with them? All of the things that we know about abuse, about sexual assault, would indicate that you would not have been able to do it. The government already fails to address these issues in the private school system. I have a number of cases that have been brought to my attention as the Shadow Minister for Prevention of Domestic Violence and Sexual Assault, where sexual assault by students, by teachers of parents, by all sorts of sexual misconduct within schools, within particularly private schools, is not able to be addressed effectively. Those cases are being shafted off to the Association of Independent Schools. Both the state and federal government who fund those schools are saying they don't have the capacity to make an investigation on this. So until the government actually takes responsibility for those kind of cases, how can they expect that doing a wishy-washy kind of amendment like this, which still leaves a wide gap in and loophole there, that they are going to do anything about it? The government's record of dealing with this matter is abysmal. The main question would be to ask, why, as legislators, are we defending the rights of non-teaching employees to have sex with children as young as 16 or 17? Why is the burden, the onus of proof on those students to prove there was a power relationship? We know that police are poorly resourced. Take an example where there might be one teacher who has committed a sexual assault again, or had a consensual even relationship with a child who is 16 or 17 and a groundskeeper 16 or 17. The police are going to go for the one where they can be assured of a conviction. These cases, I doubt, would even get to court to be considered by a court. They would have to get the police to jump through the hurdles of proving the facts that there was a power relationship. And how do you prove a power relationship? I would argue that that is nearly as difficult without something like legislation which articulates it clearly, nearly as difficult to prove as sexual intercourse taking place itself. Last year, Labor undertook a significant campaign around stopping sexual assault on campus. While the focus of that campaign was around young people in residential colleges, the underlying story that came through to us were also of university staff, for example, who were having sexual relationships with their students. And these relationships were, again, subject to pressure and stress and coercion. Now, if this is happening to students who are over the age of consent, who are actually adults, how are we dealing with our 16 and 17-year-olds? Mr. Speaker, I might ask for an extension of time, please.
Is leave granted for an extension? Yes, leave is granted. An extension of 5 minutes.
Thank you. Mr. Temporary Speaker, there are shades of grey in real life, but the law has to pick a side, and I am sick of it picking perpetrators over victims and survivors in the space of sexual assault and non-consensual and coercive sex. There are some spaces, and I would argue that schools have to be one of those spaces where if you are in a power relationship with someone, it's a criminal offence to have sex with them. And I don't believe that there is any adult who is employed by a school who does not have a power imbalance with a student. Since the beginning of the Me Too movement, revelations in all sorts of industries, the film industry, the arts, politics even, there's a society-wide conversation about power imbalances, workplace relations and predatory behaviour. It's allowed our society to understand that those in a position of power often abuse this power to pursue sexual relationships. Threats, intimidation, coercion are all tools used by those in a position of power to pressure people into uncomfortable situations, but more than that, into sexual relationships which they do not want to engage in. And we know that because the intimate personal relationships between people are so nuanced that it is very easy to push someone into a relationship that they don't want to be involved in. In a school environment, there is a clear distinction between staff and students. In our public school system, students wear a set uniform to distinguish them from staff. We acknowledge that all students are the same and that all teachers and all staff are also the same, but they are completely different, separate groups from each other. Staff members are employed to create an environment that is safe and supports education. How can that be right then that any of those members of staff would be enabled to have a sexual relationship with a student? How can a school be a safe place if some members are allowed to pursue those relationships with students? With this bill, the government had the opportunity and has the opportunity to set a clear standard. If you are employed at a school, you cannot pursue a sexual relationship with a student. It's pretty simple. This is the standard that our public, our community, our society expects. The whole point of the Royal Commission into Institutional Child Sexual Abuse was because there was a recognition that being part of an institution like the church, like a school, is people have used their power and influence to exert their sexual desires on those who are less powerful than them. Talk to most young people. A 20-year-old maintenance man dating a 17-year-old student at school, according to one of my young friends, is creepy and a power imbalance dead set. Schools shouldn't be the place for this type of relationship. Some cases have involved admin workers who have other relationships with members of the board or teachers or other people of influence within that school. Those relationships act to support their abuse and coercion. The Attorney-General is seeking to close a concerning loophole which was identified in the case of R versus PJ, but this bill will leave that loophole open. By failing to include all of the staff employed at a school in this bill, the government is knowingly allowing those in a position of power to pursue sexual relationships with students. This is not a standard that the community accepts. I implore those opposite to amend this bill to include all staff employed at a school. Thank you.
Thank you. Well, the question is the bill